Good afternoon, everybody. As I mentioned a couple of moments ago, my name's Cletus Brown. I'm from the Fair Work Ombudsman, where I'm the Director of Knowledge Solutions. Joining me this afternoon, I have Jo Cameron, a Senior Research Officer with our Practitioner Connect team. Welcome, Jo.
Thank you.
It's great to have you here. I always like having people who know what they're talking about when we do these sessions. We've got a couple of little housekeeping moments to go through. And Chevelle will answer your question in a moment. Jo, do you want to just take everyone through the housekeeping?
Yes. Now, you'll be able to hear us, or I certainly hope you can, but we aren't able to hear you. So if you have any questions or you want to communicate with us, you can use the little typing box in the bottom left-hand side. But anything you type in there will be visible to us and to all the participants as well.
Yes, and unfortunately that means that anyone who asks a really difficult question, we can't just pretend that we didn't see it, because everyone will know we're avoiding it. First off, we'd like to thank ASIAL for the opportunity to come and speak to you this afternoon. We do work closely with ASIAL, and we'll explain that throughout the next 20 minutes or so, and it's wonderful to have this opportunity today. This afternoon, Jo and I are going to speak to you about some of the work that we are doing in partnership with ASIAL, also some of the work that we do. And particularly in relation to the procurement of security services by local government. It's probably worthwhile starting out by actually explaining who the Fair Work Ombudsman is and what our role is. So, Jo, would you like to kick off proceedings and tell us what we do?
As some of you might know, the Fair Work Ombudsman is an independent statutory agency. Our jurisdiction is a national workplace relations system, so we cover most Australian employers and employees. Natalie James, whose picture you can see there, is the Fair Work Ombudsman, and we have about 800 staff in all capital cities and 18 regional centres in Australia. Our mission is to work with Australia to educate, promote fairness, ensure justice in the workplace and, where necessary, enforce compliance with Commonwealth workplace laws, primarily the Fair Work Act. The Fair Work Ombudsman is sometimes confused with the Fair Work Commission, but we are a separate organisation. The Commission is Australia's independent workplace relations tribunal and is responsible for things like unfair dismissal claims and approving workplace agreements. If the Fair Work Ombudsman wants to enforce the Fair Work Act, for example, if we find that an employer has underpaid their employees, we take that to court as we're not ourselves a tribunal.
Thanks for that, Jo. As I mentioned at the outset, we do enjoy a very strong relationship with ASIAL. Last year, we formalised that relationship by entering into a Memorandum of Understanding. This MOU helps us to work together to identify those parts of the security industry that most deserve intervention from us, the workplace regulator, and as a result, help to ensure a more level playing field for all businesses in the security industry. Now, as you're no doubt aware, legitimate businesses in many industries suffer from competitors who engage in unlawful business practices. Undercutting competitors' costs is often the easiest way to win work, and labour, of course, is one of the most significant costs in many industries. However, labour costs can only be cut so far before employees start to miss out on their minimum entitlements, often through the payment of below award wages or the misclassification of employees as independent contractors. In our experiences, these behaviours are more common in contract security industry, more common in your industry than in other industries. And the MOU gives us an opportunity to work with ASIAL to address this problem. And one of the key areas we've chosen is to work in the area of local government procurement. And Jo, do you want to just mention what we're starting to do there?
Thanks, Cletus. We're currently focusing our efforts on an area that's been identified by both us and ASIAL as particularly problematic, that is, the procurement of security services by local government. We know that in a procurement exercise, local government, like anyone else, needs to get bang for their buck. Local councils place a strong focus on getting security services for the lowest price. This results in a race to the bottom among some security contractors. As Cletus said, labour costs can only be cut so far before employees start to miss out on their minimum entitlements. When this happens, it's the employees of those security contractors, the employees who keep our community safe, who are paying the price. Security contractors who are doing the right thing by their employees can't compete for contracts with those engaging in unlawful practices, and they pay a heavy price too. Cletus, what are we doing to address this?
Indeed. Thanks, Jo. Look, we are committed to addressing this problem, primarily by working, we hope, with the local government sector across Australia to strengthen their procurement practices. Now, in partnership with ASIAL and also the relevant union, which is United Voice, we've run an education and awareness campaign. This campaign has provided local government procurement officers and managers easy access to free online information, tools and resources on our website to help them proactively monitor their security contractors' compliance with the Fair Work Act, and importantly to know when a quote is too cheap to allow security contractors to meet their employees' minimum entitlements. Now, these tools and resources are also available and they're useful for security contractors. We've been promoting our online tools and resources through the industry over the last few months, and we also recommend that everyone involved in the industry keep an eye on our website. In developing the campaign, we've looked at charge-out rates to alert local governments to when tender rates may be too low. We believe that in most cases, a figure of $24 an hour indicates that there may well be a problem with the service being offered, or at the very least, that some questions need to be asked of the security contractor. Of course, we understand that security providers are free to make their own independent decisions concerning the prices that they charge for their services and avoid any agreement or understanding between competitors on these matters. Information about cartels is available on the Australian Competition and Consumer Commission's website. Our ultimate message, though, to local government is that unlawful practices like underpayment and sham contracting are not only a problem for the security contractors engaging in these unlawful practices, but also for local government itself. This is because simply choosing the security contractor who offers the lowest price without looking closer or asking questions about how they can offer such low prices, that can expose local government to reputational damage in the event that the contractor turns out, for example, to be underpaying their employees or engaging in sham contracting practices. And this can tend to get media or community attention. Essentially, I suppose we're saying if the price appears too good to be true, it probably is. Engaging in this sort of practice can expose local government to financial penalties under the accessorial liability provisions, which are contained in Section 550 of the Fair Work Act, which Jo will discuss in more detail shortly. This year, we've done the education campaign largely last year and into the first few months of this year. But this year, we're going to follow up that education and awareness campaign with a supply chain focused compliance campaign, starting with local councils and then importantly working our way down to the security contractors themselves to deal with ongoing dodgy supply chain practices in the industry. And we're not just doing that sort of activity in the security industry, we are increasingly taking a top-down supply chain focused approach into other industries, looking into systematic non-compliance in particular industries as an alternative to our more reactive individual complaint focused approach. Jo, do you want to tell us a little bit more about Section 550 of the Fair Work Act? Because what better topic could you have first thing after lunch on a Thursday afternoon?
Thanks, Cletus. Look, Section 550 of the Fair Work Act is important. It provides for what we call accessorial liability. So under accessorial liability, it's not just the employer who actually breaches the Act that can be held responsible, but also a person or organisation who is involved in the breach. This can happen even when an organisation or person is not themselves an employer within the National Workplace Relations System, as some local councils are not. Involvement can result from being knowingly concerned in or a party to the breach, including by doing or not doing something, directly or indirectly. Knowledge of a breach can arise from willful blindness. This means that turning a blind eye can be risky. For example, if we were looking in our campaign and found that an employer was underpaying employees, liability for that breach could potentially extend well beyond that particular employer. It could extend to that contractor's officers and managers, for example, a director or human resources manager, the head contractor that contracted the security work and their officers and managers, and even to the local council that contracted the security work, including their officers and managers. So, Cletus, do you want to tell us a little bit about what's happened recently with trolley collectors working for Coles?
Yeah, thanks, Joe. We took an action under Section 550 against Coles, alleging that they were knowingly entering into contracts with trolley collector providers that meant that the trolley collector providers couldn't meet all their obligations. Now, we ended up withdrawing that action because we entered into an enforceable undertaking with Coles, and we felt that the enforceable undertaking was going to achieve better results in terms of compliance and in particular for the relevant employees than going through with legal action would have achieved. So in that enforceable undertaking, Coles acknowledged that they had responsibility to ensure that contracts that they let enabled employers to meet all their obligations. Coles also put forward a fund of monies for people who had been underpaid under the contracts that they had let, and we're progressively handing out the money to the relevant employees. And importantly for us, Coles undertook to bring their trolley collecting back in-house. So they no longer let out contracts, rather they engage the trolley collectors themselves. So it was a good, sensible and proportionate outcome for everyone involved, we thought.
So you can see just how high up that chain the accessorial liability can go. And whenever we litigate, the Fair Work Ombudsman has a policy of looking to determine whether accessorial liability proceedings are commenced. We're testing the boundaries of this when it comes to procurement chains, and we'll continue to do this in our 2015 compliance campaign. I should not overlook, however, there are some more routine ways that we use these accessorial liability provisions, and that's against company directors and office holders who are directly responsible for breaches of the Fair Work Act. For example, just this month, the owner of 3 New South Wales hairdressing salons was in court for underpaying 4 employees. His 3 companies were fined over $140,000 and he was personally fined $20,000. In this case, the court also issued an injunction on him to prevent any future underpayments, which means that as well as any future fines, he faces contempt of court charges if he's found to underpay staff again. When Section 550 accessorial liability actions are successful, these outcomes are shared with other regulators and authorities. For some individuals, the ramifications of their actions will go far beyond any fines imposed by a court. In the security industry, this could include the ability to satisfy licensing requirements, including if a particular individual starts up a new business.
Yeah, thanks, Joe. It highlights how seriously we treat these matters and how serious a problem it can be in terms of ensuring a level playing field for everybody. As I mentioned a few moments ago, our 2015 supply chain focused compliance campaign will start with local councils at the top of the supply chain, and we'll work our way down to the security contractors themselves. This means that if you provide security services to local councils, you could find your employment records being audited. You may also be audited in future as part of one of our targeted campaigns. However, there are a few simple things that you can do to make sure that a visit from the Fair Work Ombudsman won't pose any problems for you. Firstly, and most obviously, make sure your house is in order by ensuring that you're paying your employees correctly and providing them with all their minimum entitlements. Now, we have a range of resources for the security industry on our website, as I mentioned, and that website is fairwork.gov.au, which has recently been redesigned and rewritten to make it as easy as possible for you to use on your computer, your tablet or your mobile. You can still use Paycheck Plus to check base rates of pay, allowances and penalty and overtime rates under the Security Services Industry Award. Alternatively, you can download one of our useful pay guides. And over the coming months, we'd encourage you to keep a lookout for a new pay tool we're putting out there called PACT, the Pay and Conditions tool, which is an upgrade or an enhancement, if you like, of the old Paycheck Plus. In addition, you'll find that security-specific information is now built into the relevant pages across the site. All you need to do is select the security option from the drop-down menu, for example, on the annual leave page, and this information follows you as you use the site, making it easier to find information that's relevant to you. You can also set up an online account using My Account to save your favourite pages, minimum wages and awards, and to make inquiries online. Next, if you engage subcontractors yourself, you can put in place measures to proactively monitor your contractors' compliance with workplace laws. and to know when a quote is too cheap to allow those contractors to meet their employees' minimum entitlements. As I just mentioned, when it comes to procurement chains, liability for contraventions may not only rest with the direct employer. Finally, if you encounter practices that don't seem right, consider letting ASIAL know. One of the benefits of our close working relationship with ASIAL is the ability to share intelligence to identify and address unlawful practices with, as I said before, the aim of ensuring that everyone's on a level playing field in the security industry. And I speak regularly with Chris Delaney, who's the head of IR at ASIAL, and we share information about intelligence that we've gathered. I suppose in terms of knowing whether you're meeting all your obligations, you can put it quite simply that between the information that FWO's got available and the information that ASIAL makes available and their industry expertise, there is more than enough information and advice available to employers in the security industry to make sure they're doing the right thing. That's all the direct information we have for you today. As Eric has put out there and we've said at the start, we're happy to take some questions. If perchance you think of a question down the track, one of the beauties of Joe and I doing this presentation is that we can dob someone else in to take the questions afterwards. If you email questions to Andrew Jones, who's based in our Perth office, the email there, andrew.jones@fwo.gov.au. Andrew is our key industry liaison officer with ASIAL, and Andrew would be more than happy to take any questions. We just had a question. Would someone's information be kept confidential if they report or dob someone in? Look, we certainly will keep people's details confidential. The fact that someone gets dobbed in doesn't mean that we would go out and undertake a full investigation of somebody, but we use any information we gather to try over time to identify hotspots. If we knew that the allegation was very serious, we would take probably more prompt action, but we would judge it as we go. But I can't see, depending on the nature of the allegation, we wouldn't necessarily need to dob anyone in. We might give you a call ourselves and ask you to some questions about the information you've got available, but we certainly wouldn't go out to an employer saying Joe Cameron or Cletus Brown said XYZ about you, and here's their address and their telephone number and so forth. That's not the way we operate, but we do want to hear about these things so that we can take appropriate action.
What we might do then is just wait a moment to see if anyone else is furiously typing away a question for us. And if not, obviously people can direct those questions after the event to Andrew. Indeed.
Or, and I promised Chris Delaney last time I spoke to him that I'd dob him in. If you've got a question, feel free to ring Chris Delaney at ASIAL. Certainly, if he doesn't know the answer, we're probably not going to, but he'll certainly, if he doesn't know the answer, he'll ring us and ask us for our view as well. So you get a consistent answer across industry. Okay, and Erica, Chris, I'm going to dob this on you. Chris's number has been put up there. His number is 028 425 4300. I love doing this part of it. That number again, 028 425 4300. But there were no steak knives involved in ringing Chris. Okay, looks like. Hang on. A question from Chevelle there. When you're conducting audits, how will businesses be selected? Look, Chevelle, we're still working through the final stage of that plan with the Local Government Procurement Initiative. I was speaking to the relevant director, my colleague, just the other day. We're sort of looking, we'll probably target 20 to 25 local governments across the country, and we will probably just try to spread those out nationally. The more popular states will probably get more local governments doing it. We will be liaising with regulatory bodies. Where appropriate, yes, we will. We'll share information that we believe is relevant, and we'll also at times contact them to ask if they know of any or they've got any intelligence that they might like to share with us about stories that they may be hearing or trends they see are emerging. Because we're a national regulator, whilst we've got staff across, we can't, all the states, we can't be familiar with local developments at all times. in the ACT, ORS has good market information. I presume that's the local security licensing type people. We'll speak with them as we would with the security licensing people in all the states. In fact, we were at a meeting the other day with SLED, which is the New South Wales licensing people. So that'll be one of the avenues we'll use to try and gather information. Once again, I come back, it's simply to try and provide a level playing field, because our heart goes out, particularly in security and cleaning and the restaurant industry. People who are trying to do the right thing can be disadvantaged or are disadvantaged when people aren't doing the right thing. So if we can get the people doing the wrong thing to either leave that industry or start doing the right thing, then everyone can compete on an even basis, and I think everyone thinks that's a reasonable position to be in. All right, no further questions. Well, thanks very much, Joe.
Thank you, Cletus.
Great to have you along this afternoon. Thanks again to ASIAL for the opportunity to speak to you this afternoon, and we wish you all well for the rest of the week, and may your football team win on the weekend, particularly if it's Essendon. Thank you, everyone. Good afternoon.
Good afternoon.